I am not gay.
Hey, everybody, how
I
you
have
doing?
relationships with women and sex with men.
And I got news for you. That means you're gay.
How dare you?
Yeah, now we got that out of the way. Apologies for being 10 minutes late, but I was doing it all for you, the viewer. I was doing it all for you. Of course, if I had done it all for you like 20 minutes ago, I wouldn't have been 10 minutes late, but I started doing it for you about 1 minute before I was supposed to come on. As most of you know, my doggo cam crapped out yesterday because of a faulty cable. So I had to order a cable, a USB to USB Type-C cable. I ordered a 3-meter cable, and it came. Does this look like a 3-meter cable to anybody out there? This is barely a 5-inch cable. This is like a 13-centimeter. This is not a 3-meter cable. So this clearly would not do what we needed to do for the doggo cam. So I was madly scurrying about the house, trying to find another USB 2 to a USB-C cable. I found one attached to my PlayStation. That's about the cable's about this long, so I can't really move the camera around to follow the dogs. I owe everybody the doggo cam because we got the goal yesterday and the camera didn't make it. So we're gonna do the best we can while they're in the camera shot. We can have doggo cam. So this is doggo cam here today. We just start out with strawberry butt. We got strawberry butt there today. Oh God. Hey, what's up, strawberry? Howdy. Oh, you're gonna scratch your face. Right. So we start out with dog cam. It's on a very, very short leash. A little bit longer than this one, but yeah, not much. So as long as we can, we'll keep doggies in there. So we'll do our best. But that's doggo cam. Doggo cam has been unleashed, but still, you know. And it seems that we have 2 super chats. John Robert bringing the heat right from the very, 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 very beginning. As soon as I find it amidst the 140 conversations that I was late on. John Robert bringing the $50 super chat. You are late. Late vices Lamau. As I said, I was working right. I wasn't late getting here. I was late turning the camera on because I was looking out for all of you. But thank you so much for that. Lesson learned. If I'm late, people give me $50. So there you go. Lesson learned. Again, when doggos come back into doggo cam, we will focus on doggo cam. I can help. Get over there. No, you can't go into the table today. Sorry. All right. And chaos coordinator, who is always coordinating chaos. Typical Korean length. That's typical Korean cable length. I'm pretty sure that's what you were talking about, right? All right. Well, we have a little mobility with this camera, so I guess we can just turn it around here on doggos. And as we all know, today is the YNW Melly case. That's what we're looking at. We're looking at some motions filed in the case. Today, the first motion we're going to look at was not really a motion. It's a memorandum of law filed by the state. And we have to give a little bit of a background before we jump into this, but let's do that with my little furry companion. That's Strawberry there. What's that? All right, looks like we've got tard bots here. Hang on, let me all treat you like children and put this to subscribers only mode. God dang it. People are on one today, just trying to bait me, but guess what? It ain't gonna work. Not today, ISIS. How has our monetization gone limited already on this? I haven't said a damn thing. The monetization on this stream is already limited. We've already gone yellow. Oh, YouTube, you make me see that annoys me way more than stupid little impotent tard bots. But yeah, all right. You do you, YouTube. Let me put this here to subscribers only because of bots and mods. Come on, ban the bots. That's what, ban them little suckers as quick as they come in until I can set this here to subscribers. We'll start out at 1 minute and see how that goes. Well, if they do the 1 minute bots, then we'll have to go to the 5 minute. But apologies, people. It's when the children come around, we have to treat them as such. Okay, there we go. That's all taken care of. And not that, Susan, welcome to the Clean and Sober crew again. We got you last night, but it showed up here on today's stream because it kind of happened after midnight my time. All right. As some of you may know, we had a big development in the YNW Melly case last week at one of the hearings held on Thursday of last week, I believe it was. They've been trying to seat jurors since the middle of October, since like October 8th. They had a jury pool of, I believe it was 250 jurors. They bring them in, and the first thing they do in the first round of jury selection is they go, all right, who can't be here? Who can't set aside X amount of weeks of your life to handle this trial? And if you have good excuses, they say, okay, there's the door. Then they bring in you for the second round, which is, have you heard anything about this? What do you know about this? And they just kind of whittle the group down smaller and smaller and smaller until finally they're able just to kind of go through the list, pick the 12 jurors they need. And from there, they seat the jury and they start with the trial, with the opening arguments, with the opening statements, sorry. Well, as they're weeding their way through, again, they've been doing this for a month. Almost exactly a month to the day this thing happened. They've been seating the jurors, trying to seat the jurors for a month, and the prosecutor was, minding their own business, and the defense lawyers, while they were talking about the elements of the crime, they were talking about what the state has to prove. And among their statements was letting the jurors know that because the charges against YNW Melly have a gang enhancement, they're murder charges, two charges of first-degree murder with gang enhancement. The defense, now keep in mind, this is Melly's lawyers. Melly's defense lawyers are telling the jury that, hey, while the state has to prove the murders, plus because of the gang enhancement, the state also has to prove his gang affiliation. The prosecution objected to that and said, well, no. Nicola Maxwell, how are you? It's been a minute, girl. I was just thinking about you today. Anyway, I'm glad I summoned you, I guess. Sorry, squirrel brain. The state, they make an objection and they say, but Your Honor, we got a problem here. We do not actually have to prove gang affiliation in order to get the first-degree murder conviction. And there's a lot of back and forth, apparently. And what happens is the prosecution says, okay, we have a solution to this. We've read sort of the preliminary jury instructions, and the preliminary jury instructions didn't mention that the state has to prove gang affiliation in order to get a conviction on the murder charges, but the defense said we did. They told the jury we had to do this. So what we want to do is we just want to have Your Honor reread the jury instructions. Just reread the jury instructions. That will tell them, hey, the state doesn't have to prove the gang affiliation. The defense objected to that. The defense objected to that and said, but now, mind you, it was the defense that made the improper statement of law. The defense made the mistake. And the defense tells the judge, well, reading the jury instructions, that won't help us. Because if the jury finds out that we misstated the law, the jury will lose, we will lose all credibility in the eyes of the jury. That was their argument. It was a very, very interesting argument because they've made this misstatement of law. They tell the judge that, oh, there's a gang enhancement. Well, they tell the jury, the jury pool, there's a gang enhancement. The state has the burden of proving gang affiliation in order to get the conviction for the first degree murders because of the gang enhancement. Prosecution says, no, that's not what we have to prove. So what we should do is just reread the jury instructions so the jury will know this. The defense says, no, we made a mistake. But if the jury finds out we made this mistake of law, then the jury, they'll have no confidence in us whatsoever. They're going to think we don't know what we're talking about. They're not going to be able to trust us on anything. They're not going to give us any credibility. We need to dismiss the entire jury pool. So the judge said, but are you sure we want to do that? And eventually, the defense convinced the judge that simply rereading the jury instructions to say that you don't need to prove the gang enhancement in order to get the jury to convict on first-degree murder, they just threw the jury out. The judge said, okay, you're right, defense. You made a mistake. So we're going to dismiss the entire jury pool. So again, the TLDR of this is the defense makes a misstatement of law. They tell the jury pool the state has to prove the gang enhancement in order to find YNW Melly guilty of first-degree murder because they added a gang enhancement. Misstatement of law, but the defense who made the misstatement of law said, if the jury finds out we made a misstatement of the law, they'll lose all credibility, so therefore this entire jury pool has to be thrown out. Judge said, why, yes, I agree with you. Jury pool gone. All 250 or whatever they had lined up, gone. They're done. We're back to square one with the jury selection. What does that mean? Well, the opening statements were supposed to start around January 8th. We lost a month because of this dismissal of the jury pool. So we're looking at around maybe possibly the prosecution was asking for end of January, beginning of February to make up for this 1 month. The judge hasn't decided yet. The January 8th is still the official day. But what we want to look at today is the state's memorandum of law. It's the state's memorandum of law regarding the striking of the jury panel due to the defense's misstatement. Again, we already know what the result was, but the state made some interesting arguments. Steve Gauzy asked, so is the gang enhancement charged by the state or not? Yes, they're charging a gang enhancement. Two counts of first-degree murder with a gang enhancement. But the defense was saying that rather than proving gang enhancement as an additional thing, that the state had the defense of the state had the burden of proving the gang affiliation in order to get a conviction on the underlying murder charges. So let's first of all look at what the state had to say for this. I thought dismissing the entire jury pool was a very, very drastic thing to do. What the prosecution was suggesting seemed to be very, very relevant to me. It seemed very, very acceptable to me. You just reread the jury instructions, but I guess out of an abundance of caution, the judge decided just to start over. So what we want to do is read this motion, then we'll look at a little bit of an update and an interview with one of Melly's previous lawyers. So let me bring this on up. Let's see, make sure we have anything going on here. Dog Strawberry has just come back in, but ran straight under the desk. So once Strawberry gets into camera view, we'll do that because, doggo cam. Right. Sorry for all that distraction. We're just kind of trying to keep up with the dogs here so I can keep my promise to you. Right. Let's see. No more super chats to read. So let's take a peek here. This is the state's memorandum. Let's see how much bigger we can make this. There we go. State of Florida plaintiff v. Jamel Demons, defendant. State's memorandum of law, RE striking jury panels due to defense misstatement of the law. Now tell me at the end of this if you guys think this is a reasonable solution to this. And while you're at it, please just pop on down there and hit that like and subscribe button. I didn't put up a poll because I was futzing around with the doggo cam, which we don't have yet. Oh, wait a minute. We've got a stingy who looks suspiciously like Hayden there. Oops. Whoa. You don't get the big horn. You get the little one. Stingy with the $2. Legal Vice in 2030. We finally have a verdict. It's been 5 years already. So why not? Why not give it another 5 or 8 or 7 or whatever? All right. With that out of the way, thank you so much, Stingy, for that $2 super chat. Comes now, I like all this, the boilerplate word. Comes now the state of Florida by and through the undersigned assistant state attorneys and submits the memorandum of law regarding the striking of a jury panel due to defense error and comments as follows. 1. The above captioned case has been in jury selection since October 18th. I thought it was October 8th. October 18th, 2023 over the state's objection. The state, they argued, the state had previously requested that the court commence jury selection and bring back the veneer on January 8th, 2024 to begin jury selection. So you remember they were up against this October 18th deadline to start the trial under the speedy trial rules. And to start the trial, that means the initial swearing in of the initial jury pool as potential jurors. Once that happens, I guess, that is what is considered to be the beginning of the trial for the speedy trial purposes there in Florida. What the prosecution wanted to do was do that. Bring them all in, swear them all in, send them on home. Then we're going to handle all of these outstanding 30, 40, I think they're up to about 50, 50 different motions that have been submitted. They want to get all the motions done, bring the jury panel back on January 8th and begin the jury selection process. The judge said, well, no, we're not going to do that. We're going to do jury selection and motion arguing simultaneously, and we're going to start opening statements on January 8th. So so that would allow time to accomplish the litigation of motions and deposition the defense so evidently desires. On October 18th, 2023, the defendant's speedy trial was satisfied by the swearing of the veneer in light of the ruling in Smart v. State, as well as the precedent cited therein. The committee notes that the reference to the swearing in of trial jury panel for voir dire examination contained in the Florida Rule of Criminal Procedure relates to the giving of the oath contained in Florida Rule of Criminal Procedure. That oath is not required to be given in any particular location or by any particular official. Lots of cases supporting that. Well, after approximately 2 weeks of time qualifying jurors, attorney questions began on November 6th, 2023. The time qualifying is what we were talking about a little bit earlier, where they get everybody in, they go, all right, who doesn't have time for this and why not? And if there's a valid reason, they just give them the old heave-ho and they move on to the next batch. So after 2 weeks of doing that, then they started to call the jurors back for the next official round of questioning. This is where you start getting into the what have you heard, what do you know, how familiar are you with the case, et cetera, et cetera. That began on November 6th. The state spoke to the first group of prospective jurors in part on Monday, November 6th, and finished this portion of the voir dire on Tuesday, November 7th, 2023. Defense counsel began their voir dire of Group 1 on Tuesday, November 7th, 2023. During the defense counsel's voir dire, oh, you guys have no idea how difficult it is for me to pronounce that to your satisfaction. Because again, out in Utah, we're smarter than to pronounce things like voir dire. It's voir dire where I come from. We voir dire the witnesses out in Utah. So, but if I keep saying we're going to voir dire the witnesses, you're all going to jump my crap. So I have to struggle to pronounce this thing voir dire every damn time I see this word. All right, that's just more stress I need in my life. How to pronounce obscure French and Latin words. Great. All right. During defense counsel's voir dire, counsel improperly informed the jurors that the state must prove all the elements of the crime, including the defendant's gang association, beyond a reasonable doubt in order for the defendant to be found guilty. The state objected to the misstatement of law, as they should, a valid legal objection, and the court requested a sidebar. During the initial sidebar, counsel was told to rephrase the question. It says just call it VD. Well, yeah. Why not? Now I'm going to, because that's funny. All right. The state objected to the misstatement of law, a valid legal objection, and the court requested a sidebar. During that initial sidebar, counsel was told to rephrase the question. Defense counsel subsequently read the indictment to the jurors, which includes the gang enhancement language, and again indicated to the prospective jurors that the state has a burden of proving all of the elements, including the gang enhancement, beyond a reasonable doubt in order to be found guilty. Well, the state didn't take that one too well. The state once again objected to a misstatement of law. In addition, a juror, so this is the juror piping up. A juror asked for counsel to clarify, asking, "Are you telling me that if we find the defendant killed the victims, but not that it was part of the gang, that he's not guilty?" Which is a valid question. I mean, that one tells you the jury is confused, and two, there you go. They're saying, so if we find that he did kill this guy, but we don't know if he was in a gang or not, we have to vote not guilty and let him go. Well, as you may imagine, that led to a sidebar. Another sidebar was held, where the state requested that the court read the jury instructions, the law, to the jurors, which would clear up any confusion. Well, defense counsel objected to the court reading the instruction, like I keep saying, the instructions, the law, to the jurors, and vehemently argued to the court that because the state placed the language in the indictment, it becomes an element. Yeah, totally not a Russian bot says, wait, a juror that paid attention even before the trial started? Yes, as a matter of fact, it seems there was at least one. Oh, Adriana. Here's Adriana flashing all the gang signs. There you go. Gang, gang, gang. Right. So, yes, they vehemently argued to the court that because the state placed the language in the indictment, it becomes an element. Well, the prospective jurors were removed from the courtroom for further argument to take place. Let me adjust. Again, I apologize here with this very, very short cable that we're on here. All right, there you can see a sleeping Yoda. The prospective jurors were removed from the courtroom for further argument to take place. During the defense counsel's argument to the court, it became apparent the defense was under the misplaced impression that the gang language cited to in the indictment was regarding the gang aggravator under Florida Statute 921.141. Oh, so here we have this interesting situation. Counsel for the state pointed out that the state does not put aggravator language in indictments for penalty phase of trial. However, we do in fact place enhancement language in indictments. Counsel for the state also explained that the gang enhancement language under Florida Statute 874.04 is no different from the firearm enhancement language utilized in indictments under this Florida statute. So counsel for the state also made it abundantly clear that enhancement language goes towards interrogatories of a verdict form and that the defendant can be found guilty of 2 counts of first-degree murder, whether or not the jury finds the gang enhancement. They're saying that's very, very simply put, not finding gang enhancement does not mean he's not guilty if you think he committed the murders beyond a reasonable doubt. The state once again simply asked for the jury instructions to be read to the court. So just go ahead and reread the instructions. That'll set the jury straight. Everybody will be on the same page and we can move ahead. They simply asked for the jury instructions to be read to the court, something that is routinely done in jury trials throughout this courthouse and the state of Florida when a valid legal objection is made. Well, the court agreed with the state. The court agreed with the state and ruled the instruction would be read. Due to the court's ruling, defense counsel moved to strike the entire panel, quote, as he would lost all credibility with the jurors should the court read that instruction. So again, he's saying, well, if they find out we misstated the law, then they're never going to listen to anything we say because, like, we're the lawyers and we don't know what the law is. Well, the court allowed counsel to confer with the defendant, and despite the state's objection that this is not grounds for striking an entire panel, the court granted the defendant's motion to strike the panel. So again, the state said, no, let's just do this. They objected, but the judge said, well, I agree. We should just get rid of the entire jury panel. The state fears, now this may be a valid thing, but I don't think the court's going to be so eager next time to grant such a motion. The state fears that every time the state objects and said objection is sustained, the defense will move to start over because it, quote, affects their credibility with jurors. That's the slippery slope argument. Okay, if you do this once because they misstate the law, because if they get an objection sustained, then the next time they get a statement that's been an objection that's been sustained, then they're going to go, oh my God, we've been prejudiced again, and we need to dismiss the entire panel. So this is the slippery slope argument. Every time we lose an objection, does that mean the defense? Every time we win an objection, does that mean the defense is just going to cry for the jury to be dismissed? And we'll never get to the bottom of this. We'll never get to the end of this. The state fears that every time the state objects and said objection is sustained, the defense will move to start over because it affects their credibility with the jurors. For centuries, the rules of evidence have existed and lawyers on both sides have objected in front of jurors where they are either sustained or overruled. It is also quite common for lawyers to misstate the law during voir dire, at which time courts have consistently jumped in and read the jury instructions to jurors to rectify the issue. It is within the sound discretion of the court to strike a panel. So yeah, the state's admitting that the judge does have the discretion to strike a panel of jurors. The Florida Supreme Court found that a trial court's subsequent comments to prospective jurors during a voir dire after a misstatement of the law by an attorney were consistent with the standard jury instructions. The court in Franqui replied that Hinyard v. State relied upon. So when you get these people that are just firing these motions and these briefs in, you get some misstatements and some bad grammar sometimes. So the Florida Supreme Court found the misstatement was an isolated statement and was harmless. That dog in him, don't worry. Don't worry, I'm with you. All right. Furthermore, a total of 3 jurors have now come forward regarding improper conduct. Well, maybe it's time to address it now. Steve's here in chat. Hey, Mr. Steve Gosney. He's talking about the enhancement and wants to see the language of the enhancement and not. That's not what we're talking about here. The judge has already decided it was a misstatement of law. The judge, so it's not whether or not there was a misstatement of law. The judge already decided we're just talking about the dismissal of the entire jury panel, which the court has already done. The entire jury panel has already been dismissed. We're just looking at the state's reasoning behind why it shouldn't have been done and why we have to be careful about moving forward. So the actual language of the gang enhancement isn't really the focus of what we're looking at here. And the dog in them said Gosney would rather type it out, hoping Vices would see it. Don't you know he doesn't look at chat while he's reading? Well, I do. I kind of have a little peripheral vision. That's why I saw this. Also, if you do read this, I demand max snark. Well, there's your maximum snark. Arr. And Grant Roshawalrad, it says, Jeff says it one way, voir dire, or voir dire, and his 5 wives in Utah would say it differently too. Well, I couldn't handle one of those, and it wasn't even in Utah. So yeah, 5 of them are right out. Not for me. Thank you very much. I don't even want one anymore. Okay, let's jump back in here. 18. Further, this is an interesting thing as well. A total of 3 jurors have now come forward regarding improper conduct, both by known and unknown individuals. The state has expressed serious concerns for the integrity of the jury selection process. We talked about one of them being YNW Melly's mother, who was hanging out where the jurors come in and out of the courtroom, crying into a cloth. Apparently, one of them said was trying to communicate aggressively with her eyes or something like that. And now she's not allowed back she's allowed back in the courtroom, but she's not allowed to have any contact with jurors, et cetera, et cetera. We talked about that last week. The state has expressed serious concerns for the integrity of the jury selection process, this case, and the judicial system as a whole. The state did not move to strike the panel despite the grave concerns it has for jury tampering. We didn't do it for a much more serious thing, but they did it for something less. That's their argument. For what it's worth, they probably could have, but they didn't. The state merely asked for the jurors to be questioned in accordance with the law. We read through that last week. They abrogated on other grounds, and there's a bunch of cases they cite there. Although the court originally agreed to question the jurors as a group and not individually, the court subsequently denied such a request when reminded of it on Monday, November 6th, 2023. Yet, after a valid legal objection was sustained, the panel is struck at the request of the defense. While the state understands the court acting in an abundance of caution, objections being sustained and jury instructions being read by the court to rectify the misstatement of law should not rise to the level of starting over. All of this time being spent on jurors that have now been struck could have gone to time both sides clearly need to further prepare for trial. This goes back to the arguments that they made at the beginning when they said, why don't we just swear the jury panel in, send them away for a couple of months. We'll spend the next two months arguing about motions, getting the motions litigated, everything set. Then we'll bring them back in January and start the selection process. They're saying that all of this time that we could have been doing that is now wasted because the defense got this little motion sustained. The state does not want this to become a pattern where each objection made, another group of jurors is struck. Here's a little footnote. I don't usually read footnotes, but footnotes can be fun sometimes. This was their jury tampering thing. Juror number 3, not associated with law enforcement in any way, of jury group 1 came forward after state's voir dire regarding other approaching jurors and walking in the hallway in front of jurors. Juror 3 indicated that she left jury duty for one day on October 18th, 2023, the first day of jury selection, and went back to the juror parking garage. She decided to meet her husband on the street outside the juror parking garage, where she was approached by an unknown female regarding her jury service on the, quote, rappers case. And I hereby certify that a true and copy of this has been filed. That's the state's memorandum of law on why the dismissal shouldn't have happened. And where are we at here? There we go. That's what I need. Boom. Didn't mean to close both of those windows. Right. And there. We'll bring this up here in just a little bit. But for now, that's That's essentially what the memorandum of law is. We just want to get this on the record. We just want to say this. We know what you did. We understand why you did it, and we understand you're within your legal rights to do it. But we do want to get this gripe out there. And what do you? I mean, I think the prosecution is probably right. Now we'll see that Steve mentions here. This just gave let's try this again. This just gave them an excuse because the court clearly wanted to punt this case. That's something I thought about. Is it, I was wondering, maybe did the judge see that there is no way in hell they're going to be done seating the jurors as well as arguing their way through 30 outstanding motions before the January 8th timeframe rolls around. So that's one thing I was thinking. Okay, if we just give them this, then that's going to delay things at least another month, possibly 6 weeks. That'll give us more time. Or did he just give it to the defense because they asked for it? The state's argument that, well, we could have asked for it too, but we didn't, doesn't really mean that the defense can't ask for it and wouldn't be entitled to get it. What do you guys think? Is this a delay tactic, or is this a valid concern that the judge should have? Throw it out to you lay people in the jury, and I guess lawyers are allowed to answer the question too. Put a 1 in chat if you think this is just a delay tactic by the judge to allow more time for the motions to be argued and the jury to be set. Or 2, is it an actual valid? Well, it is a valid legal decision because he did it. Or is it just an appropriate thing to do based on the motion that was submitted? So I guess that's kind of what. I know that isn't really exactly a clear choice, but is it the judge finding a reason or an excuse to delay it for a couple of months, or is it an appropriate thing for that? Well, yeah, it doesn't really matter. You're all saying it's 88 flux. No, you're all saying that. I'm going to assume, because Steve wrote about it up there in the chat, that he's going with a 1 on that as well. But it happened. Well, there we go. Here's a long comment from Steve. Yes, but the state cannot really appeal an adverse ruling like that, while the granting by the court ruling for the defense, doing what the defense requests, resets the table, clean up the appellate issues. Yeah, we're back to square one. It's literally back to square one. We got to find a whole new jury panel and go over this from the beginning, from the big inning. And that's what we're doing. So settle in. We got a lot of motions to go through over the next however long it takes for them to seat a new jury. Well, there is a question. There's a couple of questions that remain outstanding. And I mean, you guys have outstanding questions. That's what I was, But this is it's questions that have not been resolved to your satisfaction. And one of them you asked a long time ago when Prosecutor Bradley got chucked off the case. We're like, well, why did she get thrown off the case? And why didn't the others get thrown off the case? Well, that's the first thing we want to look at today. Why did she get thrown off the case? And if we have time, we'll look at why didn't the other prosecutors get thrown off the case? Well, because the last time we addressed this, we didn't have the submissions, and we didn't have the court's order. But what we've got today is the order denying the defendant's motion. Oh, that's the never mind. I brought up the wrong one. That's the one we want to look at if we have time. We want the order granting the recusal of Ms. Bradley. Oh, this is a fun case. Just when you think we're about to get ready to go for more, this happens and we get months and months of delays. I'm starting to, even if he is guilty of committing 2 first-degree murders, I kind of feel bad for they could just be sitting there for 5 years waiting to begin the rest of his life, whether it's inside of the jail or outside of the jail. We're 5 years into this. That's a long time. Right. Well, let's go and take a look at this. Do we have any? We don't have any of the monthly chats lined up here, and the super chats are all up to date. How are we doing on the? We got 550 concurrent viewers. Good. That's a big number. That's great. We've got 258 likes. That's like a less than 50% number. So I did have time, but I didn't to put up a poll. So please do me a quick favor here while we're 41 minutes into this. Just pop down there really quick and hit that like button while I'm bringing up this next order from the court. And while you're down there clicking that like button, just look over and see if you're subscribed. If you're not, do me a favor, hit that subscribe button and sign up for the notifications so you don't miss any of our YNW Melly motions and updates and news, etc., and hearings that are broadcast as we go forward. And then once actual opening statements begin, we'll do gavel to gavel coverage the way we did the first trial. And take a risk, subscribe if you are subscribed. Just make sure you're still subscribed. And let's go. Thank you so much for the 30 likes that just came in. We still need about 200 more. We should be up to 500 or 600 likes by now because you guys rock. All right. And we've got the dogs have come back into range here. Oh, good. And Strawberry brought her noisy chew toy. Great. Right, folks. What we're going to look at now is what we were talking about a moment ago. Let me bring up the screen. All right. Yeah, please chew that right there under my feet. And here we go. Let's embiggen it. Which means we need to ensmallen me. This is the order granting the defendant's motion to recuse 17th Judicial Circuit Assistant State Attorney Christine Bradley. As you may recall, she was accused of doing a lot of things, including not turning over exculpatory evidence or evidence of evidence that could affect her main witness's credibility. Oh, and by the way, there is big news. As we mentioned last week, the judge has allowed the defense the opportunity to take a second deposition of lead detective Moretti. But the judge placed a limiting, I guess, instruction on it saying he can't be asked about any of the evidence in this case, but he can be asked about things that go to his credibility. And that deposition of lead detective Moretti, the second deposition of lead detective Moretti, will happen on the 17th. So 3 days from now, his deposition will begin, and I hope it's a very, very long, very, very painful deposition for him. If anybody deserves to be deposed aggressively and for a very, very long time, it's him. Well, here we go again with the state of Florida plaintiff versus Jamel Demons defendant. Judge John J. Murphy III presiding, order granting defendant's motion to recuse 17th Judicial Circuit Assistant State Attorney Christine Bradley. So this is the judge issuing the order to boot her off the case. This cause came before the court on defendant's motion to recuse State Attorney's Office of the 17th Judicial Circuit in and for Broward County, Florida, filed on September 29, 2023. The state filed a response on October 6, 2023. I don't have a copy of that, or we'd read it. The court held hearings on the motion on October 6th and October 11th. Having considered the state's motion, the evidence presented, arguments of counsel, the court file, applicable law, and otherwise being fully advised, this court finds as follows. Defendant intends to call Assistant State Attorney Michelle Boutros and lead prosecutor Assistant State Attorney Christine Bradley, in this case, in chief, to impeach the testimony of the lead detective in this case, Detective Mark Moretti. Let me see if we can flip the old camera around while we're doing this here. Oh, we are on a very short leash. Oh, there we go. That's as good as we're going to get. Sorry. All right, so I guess to bring you up in a very, very quick, up to speed, little background information. The idea was Detective Moretti, the lead detective, was serving a search warrant out of his jurisdiction against YNW Melly's mother. He needed someone there. he needed someone from that jurisdiction present with him when he served it. He didn't. But for some reason, one of the people in the room was Michelle Boutros, who is a member of the prosecutor's office, but it's her job. She's had the job for the last 20 years of prosecuting bad cops and bad lawyers. That's kind of what her job was. And she just happened to be there when Moretti told a guy who nobody says was in the room when the search warrant was served on YNW Melly's mother, and her phone was allegedly removed from her possession with an excessive amount of force, is what they're saying. But this other police officer in that jurisdiction was outside of the room, and Boutros, Prosecutor Boutros, she overheard Detective Mark Moretti ask this guy if he would say that he was in the room with them when this was served. And the officer responded, "I was there if you needed me to be." In other words, I wasn't in there, but if you need me to say I was in there, okay, I was in there, and I will say that. Boutros reported it to her superiors there in the attorney's office, in the prosecutor's office, in the district attorney's office. They didn't do anything about it, and Christine Bradley knew about it. She didn't tell the defense, which the defense argues is a Brady violation, because that would go directly to Detective Moretti's credibility as a witness if he's soliciting other officers to falsify statements. So this becomes an issue. The defense says, well, I'll tell you what, when you put the lead detective on the stand during the retrial, we're calling in Miss Boutros, who overheard this, to testify against his credibility, to attack his credibility. And she's more than happy to do so. She's already testified. The prosecutor, Michelle Boutros, has already testified on behalf of the defense in this case during the hearing to get Christine Bradley booted out. But not only are they calling Michelle Boutros, who overheard this statement, they said that they are going to call 100%. They said they are going to call Christine Bradley, the lead prosecutor in the first prosecution, as a witness to attack her own witness's credibility. So again, if she's going to be a witness, can't be a prosecutor on the same case. So defendant intends to call Assistant State Attorney Michelle Boutros and lead prosecutor Assistant State Attorney Christine Bradley in his case in chief to impeach the testimony of the lead detective, in this case, Detective Mark Moretti. At the hearing on the motion, Ms. Boutros testified that she was present when Detective Moretti executed a search warrant for defendant's mother's cellular phone on October 12th, 2022. This is over a year ago, and they just found out about it. Although the search warrant was executed at the state attorney's office in Broward County Judicial Complex building, no Broward Sheriff's Office deputy was present during the execution of the search warrant. Ms. Boutros also testified that when BSO Deputy Adam Gorell later entered the room, Detective Moretti instructed him to say he was present when the search warrant was executed. Now, again, this is what the judge found. This is the judge's finding. This is the judge's order. So, the Detective Moretti instructed him to say that he was present when the search warrant was executed, even though he was not. Ms. Boutros did not believe that Detective Moretti was joking and was perturbed by what took place. On October 18th, 2022, Ms. Boutros met with State Attorney Harold Pryor, Chief Assistant State Attorney Regina Falk, and Assistant State Attorney Christopher Killeran, who is her immediate supervisor, to discuss the incident. Shortly thereafter, State Attorney's Office administrators met with Ms. Bradley about the incident. Again, Ms. Bradley, she was the lead prosecutor in the first Melly trial. However, this information was not disclosed to the defense until after the defendant's first trial resulted in a mistrial. Yeah, they knew Moretti was doing this. They knew months before the trial started. that he was doing stuff that would go to his credibility. They shelved it. They shelved an internal affairs investigation against him. They didn't tell the defense that this guy they're going to call has credibility issues. They put him on the stand. They didn't tell the defense during the trial. They didn't even tell the defense after the trial until August 30th, 2023. They filed another Bradley notice. So again, we've talked about this before. The prosecution has a duty to turn over everything they have, not only that shows the guilt of the defendant, but also exculpates the defense, or is evidence that he didn't do it, or information and evidence that if they know that there's credibility issues for one of their witnesses. If they know that their guy has credibility issues, they have an affirmative duty to tell the other side about it, to tell the defense about it. The defense doesn't even have to ask. This is an automatic requirement that the prosecution must do this, but the defense asked nicely a couple of times anyway, sort of saying, okay, we know you have this duty and you've done it clearly because we wouldn't suspect otherwise, but just in case you haven't, just in case there's a few more documents laying around the office that you haven't given us yet, here's your notice to turn those over to us. They did that twice, if I recall correctly. Oh, excuse me, am I getting a stuffy nose here? So, however, this information was not disclosed to the defense until after the defendant's first trial resulted in a mistrial. Additionally, there were conflicting Brady notices that were filed as to whether Detective Moretti admitted to making the statement to Deputy Gurrell. On August 30th, 2023, a Brady notice was filed by Ms. Bradley, in which she disclosed only that there was an internal affairs complaint lodged against Jamie Demons King with the Miramar Police Department in relation to the execution of the search warrant. So that would raise some flags, okay? There was an internal affairs investigation that had something to do with this search warrant that was served on the defendant's mother. Okay, well, that clearly raises questions. So the Brady notice makes no mention of Ms. Boutros' statement that Detective Moretti instructed Deputy Gurrell to say he was in the room when the search warrant was executed, even though he was not present. Nor did it mention Mrs. Boutros' complaint to the Internal Affairs regarding the search warrant incident. Ms. King was not present in the room when Detective Moretti made the statement to Deputy Gurrell, so there was no possibility that it would have been included in her complaint. Well, in September of 2023, Ms. Boutros discovered that no Brady notice had been filed in this case, disclosing what she overheard Detective Moretti tell Deputy Gurrell. So not only did she rat out Detective Moretti to her superiors and to the other prosecutors involved in this case at the time it happened, later, when it comes time around to look through these Brady motions, these Brady submissions, she says, wait a minute, none of that stuff I told you guys last year is in this. That's a problem. So she gets to rat out the same people twice. She immediately brought this to the attention of the state attorney's office administrators in a meeting held on September 18th, 2023. Everyone involved agreed that a Brady notice had to be filed. So everyone involved went, oh, crap. Yeah, we need to rectify this. This should have been done. Well, it should have been done before the first trial. But they're saying, yeah, we need to do this. We should let them know now what happened before the first trial. Little bit late on that. So they all agreed. They all agreed that a Brady notice had to be filed. Administrators then followed up with Ms. Bradley in at least 2 meetings. On September 23rd, Mr. Killeran drafted a Brady notice and sent it to Ms. Bradley to file. However, she did not file that notice. Why is my nose running? Let me talk to Strawberry here for a second. All right, silly dog. Again, see, now you can see, this is what happens. I mentioned this before, that there's this little strip of hollow aluminum that she likes to put her loud chew toys in, which resonates. And so that's why it might be a little bit loud. We'll just have to deal with it. So first of all, they did not tell the defense about what Moretti had done before the first trial, when they should have. They didn't tell the defense about what Moretti did during the trial when they called him as a witness, which kind of would be the backup if they didn't do it before then. They didn't come after the mistrial and say, by the way, we forgot to tell you this. Ms. Boutros again finds out that this wasn't done, so she rats them out again and says this was never done. Everybody said, oh my God, we really need to get this done. We need to put this in. We need to put this in the record. We need to get this Brady notice out to the defense. They told Ms. Bradley to do this. They drafted this notice. And gave it to Ms. Bradley and said, file this with the court. And she didn't do it. She did not file this notice again. Well, how do you think that went over? On September 22nd, 2023, Ms. Boutros was contacted by counsel for defendant. A state attorney's office administrators authorized her to speak openly and honestly with counsel about the incident. So counsel for the defendant calls Ms. Boutros and says, what's going on here? And her own office said, yep, just tell him. Oh, well, that was nice. Doggo cam shut off for some reason. I don't know. So yeah, they're saying, we don't know. Just tell him what happened. Be open, be honest, just tell him everything. So I guess she did. She spoke openly and honestly with counsel about the incident. Then, the next day, the first Brady notice concerning Detective Moretti's statement to Deputy Gurrell was filed. So 11 months, damn near a year after this incident occurred, after numerous opportunities for Bradley to tell the defense what had happened, which they should have done months before the trial, the minute that it became known what had happened, it should have been told to the defense. Took a year after the trial was over, and only because they were ratted out again by Prosecutor Boutros. So in September of 2023, the state filed the following Brady notices regarding Detective Moretti's statement to Deputy Gurrell after the execution of the search warrant of Jamie King's cellular phone. September 23, 2023. According to Assistant State Attorney Boutros, she's the good prosecutor, Detective Moretti executed a search warrant during an interview with Jamie King, while no BSO deputy was present in the room. Shortly thereafter, BSO Deputy Gurrell entered the room and was told by Detective Moretti to say he was present when Detective Moretti executed the search warrant, seizing Ms. King's cellular phone. So this is an admission by the prosecutor as to what happened, as well as the judge acknowledging this in his order to remove Bradley from the case. Keep this in mind. This is coming from the judge. This isn't an assertion. This is an argument. This is what the prosecution submitted, and this is what the court is ordering on. So Detective Moretti, told by Deputy Gurrell, entered the room and was told by Detective Moretti to say he was present when Detective Moretti executed the search warrant, seizing Ms. King's cellular phone. The undersigned, Ms. Bradley, spoke to Detective Moretti, who said that he asked Deputy Gurrell if he was present when the search warrant was executed, to which Deputy Gurrell responded, "I can be if you needed me to be." This Brady notice was signed by Ms. Bradley. I can be if you needed me to be. That's past tense. It's not like, okay, I'm gonna execute this search warrant. Can you come in the room with me And he replied, well, I can be if you need me to be. This is after it happened. This is past tense. He says, Deputy Gurrell, you know that search warrant that I served, you were in the room, right? Wink, 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 right? You were in the room when I served this, right? Because it would have been illegal, and it wouldn't have been proper service if you weren't. So you were there, right? To which he responded, oh, I can be in the room if you needed me to be there when it happened. This is how people are wrongfully convicted. Whether that's the case in Melly's situation or not, I don't know, but this is the police manufacturing evidence, falsifying statements. No, that's exactly what's not supposed to happen. Well, 3 days later, on September 26th, 2023, they file an amended Brady notice. I know we told you everything 3 days ago, but we need to amend it a little bit. They filed an amended Brady notice stating that the lead ASA assigned to the case told administrators at the state attorney's office that she spoke with Detective Moretti in regards to his statement to Deputy Gurrell. The statement was, you were present, right? And he said, oh, I can be if you needed me to be. So Moretti explained that his statement to Deputy Gurrell was a joke. Well, it's just a joke. It's a joke. Oh yeah. When I asked him if he was present when I did this, because if he wasn't, it would be invalid and that would make it illegal. When I asked him if he was there and he wasn't, that was just a joke. And this was 3 days after they put this. So we need to amend that to say it was just a joke. That is some grade A government inspected BS right there. Yeah, Detective Moretti, it was a joke. Subsequently, the lead assistant state attorney filed a Brady notice with the court on September 23rd, stating that Detective Moretti asked Deputy Gurrell if he was present when the search warrant was executed, to which Deputy Gurrell responded, I can be if you needed me to be. The lead ASA relayed to the state attorney's office administrator that Deputy was the one trying to be funny. Okay, so yeah. Moretti says, oh, no, I was just joking. My statement to Deputy Gurrell, asking him if he was there, that was a joke. But then they went, oh, wait a minute. No, it wasn't Moretti's joke. It was Gurrell's joke. Gurrell was joking when he said, I can be if you needed me to be. Oh, it's all just somebody's joking. It's a joke by somebody. It could be Moretti's joke. It could be Gurrell's joke, but somebody was joking. Oh, Deputy was just trying to be funny. This Brady notice was signed and filed by Assistant State Attorney Killeran, higher up the food chain than Bradley and Boutros. Well, 2 days later, the state finds it necessary to file a second amended Brady notice. Okay, when we said this is what happened, and then we amended it to say no, everybody was joking. Everybody was joking. We should have put that in the first one, but we forgot. So now we're going to amend it. So everybody was joking. Well, 2 days later, like, okay, wait a minute. We still need to change a few things. We still need to clarify a few things here. So the state filed a second amended Brady notice stating that the undersigned Ms. Bradley, so this is Ms. Bradley filing it again, inaccurately relayed to state's attorney's office administrators that Detective Moretti told her that his statement was a joke. Chat, I'm going to let you tell me what that means. Prosecutor Bradley says, this is what happened. He said this. Moretti said this, and Gurrell said that. 3 days later, her boss submits a statement going, okay, I talked to everybody. Bradley told me that Moretti said he was joking. Then 2 days later, Bradley has to submit another statement saying, what, and tell me, what does this mean, people? What does this mean to you? Ms. Bradley inaccurately relayed information. She inaccurately told the state administrators that Detective Moretti told her his statement was a joke. When I told you I was joking. Okay, well, I inaccurately relayed that he was joking. It means that she lied. She lied to state attorney's office administrators that Detective Moretti told her that his statement was a joke. She lied. He didn't tell her that. And they made her go back and amend that to say, oh, not that she can't say, I just effing lied to the state attorney's office about Moretti saying this was a joke. No, she inaccurately relayed to the state's attorney's administrators that Detective Moretti told her it wasn't a lie. She just inaccurately relayed the information. So next time you get pulled over by the police and they go, oh, how fast were you going? And you say, oh, I was going 12 miles an hour. And they show, oh, well, here's our radar. Here's all this. This is showing you were going 65 in a 30. You can say, oh, I inaccurately relayed information to you that I was going 12. See how far that gets you. See if they go, oh, okay, all right. Thank you for that clarification. No, she lied. She had to go back and she had to sign that she lied. Or, oh, I'm sorry, she didn't lie. She inaccurately relayed to her bosses that Moretti told her the statement was a joke. The Brady notice was filed and signed by Ms. Bradley. Well, we fast forward another week. At the October 6th hearing, contrary to what was contained in her September 28th Brady notice, Ms. Bradley testified that she never told state's attorney's office administrators that Detective Moretti told her that his statement to Gorell was a joke. Now, how about that shit? How about that shit right there? Let's go back in time. 26th, she says, hey, look, this is what happened. He said this, and then this happened. Then 2 days later, she tells her bosses. She goes, oh, that's not what I meant. I meant, Moretti told me he was joking. Moretti told me he was joking when he said that. Then 2 days later, she's forced to go, oh, wait a minute. I inaccurately relayed that information. I lied. And now, when she is in this hearing on October 6th, she contradicts that and says, I never told state attorney's office that he said that it was a joke. Not that she inaccurately relayed. So she says it's a joke. Then she says, oh, I inaccurately relayed information that it was a joke. Then on the stand, she says, I never said that in the first place. So it went from saying it to saying it was a joke to saying, oh, I inaccurately said it was a joke to I never effing said it in the first place. This is her fourth version of this story. This is the fourth version of this story. Rather, she told administrators, no, I never said he was joking. Rather, I told administrators that when Detective Moretti asked Deputy Gorell if he was present during the execution of the search warrant, he responded, I can be if you needed me to be. And then she told the administrators that the deputy was the one trying to be funny. If you're keeping score at home, Moretti said this. Moretti was joking when he said that. Oh, I lied about saying it was a joke when he said that. Oh, he didn't say that. It was actually the other deputy, the one that wasn't in the room. He was the one that was trying to be funny when he said I was there if you needed me to be. Holy crap. This is bad. This is scary. This could happen to any one of you, not just people accused of murder. Haas Knuckles, hey, Jeff, just remember, it's all about the he said, she said bullshit. And we all know.
Everything that guy just said is bullshit. Thank you.
That is literally all that the defense is going to have to say when Detective Moretti takes the stand. Yikes. So yeah, thanks you again so much for Haas Knuckles for that super chat. Deeply appreciated. So let's see how they get out of this one, shall we? And again, I remind you unnecessarily for the 947th time, this is not an assertion being made by the defense. This is in an order by the judge. This is accepted as what happened. And it's on the record in all of these different Brady notices, the Brady notice, the amended Brady notice, the second amended Brady notice, the transcripts of the trial of the hearing she was at. So it was now it had nothing to do with Detective Moretti. It was Deputy Gorell. He was the one trying to be the funny son of a bitch. Yeah, Deputy Gorell was the one joking. Rather, she told administrators the deputy was the one trying to be funny. She testified that the administrators must have interpreted her statement to them and that the information contained in Mr. Killeran's Brady notice was not an accurate representation of what she told them. Oh, see, I told them it was the deputy that was being the funny guy, but my boss, the dimwit, the dumbass, he misinterpreted when I said the deputy was the funny guy to mean Detective Moretti, the lead detective on the case, was a funny. It was just a mistake. I said deputy was being funny guy. I said Deputy Gorell was being funny guy. He heard lead detective Moretti was being the funny guy. It's just, he misinterpreted it. Ms. Boutros testified that on September 27th, again, Ms. Boutros is the good prosecutor. She's the one that ratted all this bullshit out. Ms. Boutros testified that on September 27th, 2023, she learned that Ms. Bradley had accused her of lying to several colleagues in the office the previous day. So when she first ratted this out on September 26th, she hears from people that Bradley is saying that she lied. Bradley is telling people Boutros was lying on the stand. Can you believe that? Well, I guess you probably can, because that's the kind of person she seems to be. During her testimony, Ms. Bradley conceded that she did not file a Brady notice immediately after her conversation with Detective Moretti regarding a statement to Deputy Gorell, which took place before the first trial. Where members of the state's attorney's office are either material witnesses or otherwise involved with the facts or outcome of a case, other courts have required that a showing of actual prejudice be made before a motion for disqualification of the prosecuting attorney is properly granted. Let's read through that slowly again. Where members of the state's attorney's offices are either material witnesses or otherwise involved with the facts or outcome of a case, our courts have required a showing of actual prejudice be made before a motion for disqualification of the prosecuting attorney is properly granted. So where our guys are witnesses, where the prosecutor's guys are witnesses, we have to show there's some actual prejudice in the case before we disqualify them from prosecuting the case. So we need to find, was her statement prejudicial? Did it create prejudice against the defendant in this case? Well, hell yeah. Yeah, it did. Spoiler alert. However, the functions of a witness and a prosecuting attorney must be kept separate and distinct, and that the practice of acting as both prosecutor and witness is not to be approved and should be indulged in only under exceptional circumstances. It's another case. There are 4 policies underlying the general disapproval of an advocate also acting as a witness. Unless it's very exceptional circumstances, they shouldn't be allowed to be prosecutor and witness. And there's four general policies that drive this. First, the rule eliminates the risk that a testifying prosecutor will not be a fully objective witness, given his position as an advocate for the government. First, witnesses are supposed to be objective. And they're saying, well, if the prosecutor is trying to get the person thrown in jail, so if they're a witness in a case where they're trying to put somebody in jail, they're probably not going to be an objective witness. So that's one reason. Second, there is the fear that the prestige or prominence of a government prosecutor's office will artificially enhance his credibility as a witness. Imagine Detective Bradley says, okay, no further questions for this witness. For our next witness, the state calls me. The prosecutor goes and sits on the stand. The prosecutor answers questions as a witness. Then the prosecutor gets down and calls the next witness. The second policy here says if that happens, there's a good chance the jury is going to go, oh my God, the prosecutor is a witness in this case. The prosecutor is a very prestigious person. They're in a very prestigious position. They wouldn't lie. So they would give undue weight to the prosecutor's opinion if the prosecutor testifies as a witness. Third, the performance of dual roles by a prosecutor might create confusion on the part of the trier of fact, the jury, as to whether the prosecutor is speaking in the capacity of an advocate or as a witness, thus raising the possibility of the trier according testimony credit to the prosecutor's closing argument. So it could confuse the jury. Okay, this person was on the stand. Was that them actually being a witness, or were they just giving their opinions as a prosecutor? It's confusing for us. And fourth, the rule reflects a broader concern for public confidence in the administration of justice and implements the maxim that justice must satisfy the appearance of justice. So it'll look squirrely. That's the fourth argument. It'll look squirrely if the prosecutor does that. So those are four reasons why it's a bad policy to have the prosecutor serve both as witness and prosecutor in the same case. There's a greater potential of prejudice when a trier of fact is a jury rather than a judge. So again, the trier of the fact can be a jury or a judge, but in this case, there's a jury, so the trier of fact is the jury, and they're saying that all of these policies, it's not so much a bigger problem for a judge, because the judge can filter this stuff out. But a jury is going to be more confusing to them because they're laymen. Even if it is unnecessary to disqualify the entire state attorney's office, the court must disqualify individual prosecutors when a defendant has been irreparably harmed and has suffered actual prejudice. See Nunez v. State. The prosecutor not only had the opportunity to hear privileged communication. This is the summary of Nunez v. State. The prosecutor in this other case not only had the opportunity to hear privileged communication between the defendant and his counsel, he also observed the exchange between the defendant and his counsel and intended to use the videotape of this exchange in the prosecution of the state's case. So when a prosecutor is called as a witness to testify as to a contested issue, he or she places his or her credibility at issue before the jury and acts in a dual role as prosecutor and witness, and he effectively vouches for his own credibility by returning to the role of the advocate. That's what we were just saying. He says, I'm the prosecutor. You have to believe me because I'm the prosecutor. Oh, now I'm the witness, and you have to believe me as a witness because I'm in this vaunted position. And then I go back to being a prosecutor and say, aha, that was our witness. Our witness must be credible, so I must be extra credible. The better practice would be for the prosecutor who becomes a witness to withdraw from the actual prosecution of the case. So that's the best practice. You become a witness, you're off the case. The state argues that Ms. Bradley's testimony would be inadmissible at trial, so because it would constitute inadmissible impeachment on a collateral matter. Long story short on that, the search warrant for her phone, for Melly's mother's phone, was not related to the murder case. It was related to the separate investigation they were conducting regarding jury tampering, which Melly's ultimately been tried about, and we'll talk about those on a different show. But they were investigating whether or not YNW Melly and YNW Bortland had been tampering with witnesses. So in relation to those charges, they were trying to execute this search warrant. And they're saying, well, you can't use things from this other matter, the other matter of witness tampering. You can't use things that happened there to impeach the witnesses in this separate, unrelated collateral matter. That's generally what they were saying. So the state argues that Ms. Bradley's testimony would be inadmissible at trial because it would constitute inadmissible impeachment on a collateral matter. The court is not persuaded by this argument. So the court says, nah, I think you're wrong. The court is not persuaded by this argument and finds that any testimony concerning Deputy Moretti's purported statement to Deputy Gurrell, inducing him to lie about being present during the execution of the search warrant, is material and falls within the exception to the collateral impeachment rule. So there's the judge saying this is a material fact. This is a material matter that directly relates to his impeachment in this trial, his credibility as a witness in this trial. And they cite Mitchell v. State, where there is any doubt that a witness might have bias or motive to exaggerate or even fabricate his or her testimony, the defendant has the right to explore that bias or motive before the jury. And another case, extrinsic evidence is admissible for collateral impeachment as evidence which would discredit. So other evidence, outside evidence, can be admissible in a separate impeachment as evidence that would discredit a witness by pointing out the witness's bias, corruption, or lack of competency. There is a sufficient likelihood that Ms. Bradley will be called by the defense. They said they're going to. This is without a doubt. If Moretti takes the stand, Bradley's taken the stand. They've flat out said that. There is sufficient likelihood that Ms. Bradley will be called by the defense to testify as to necessary and admissible impeachment of Detective Moretti's testimony. Because she spoke with Detective Moretti about his statement to Deputy Gurrell, she is directly involved in the incident and by testifying would place her credibility at issue such that there is sufficient likelihood of actual prejudice to the defendant. Additionally, substantial misconduct, which is something more than the mere appearance of impropriety, can establish actual prejudice to warrant the disqualification of a prosecutor. So the judge is essentially calling Prosecutor Bradley out for substantial misconduct. Given the conflicting Brady notices, again, there was the original Brady notice, the amended Brady notice, the second amended Brady notice, and her testimony on the stand, she gave 4 different stories of what went down between her and Gurrell and Moretti. So given the conflicting Brady notices, the apparent internal conflict between administrators of the state attorney's office and Ms. Bradley as to what she told them regarding Detective Moretti's statement, and Ms. Bradley's as to what she told them regarding Detective Moretti's statement, and Ms. Bradley, read that twice, and Ms. Bradley's apparent personal animus towards Ms. Boutros. Again, so Ms. Bradley hates Ms. Boutros because she was lying to other people in the office saying that Boutros was lying about her. So she's got internal conflicts in her own statements. There's conflict in her office. The state, her bosses say she said one thing. She says that she told her bosses another thing. Plus she hates Ms. Boutros, as demonstrated by her accusations that Ms. Boutros was lying. There is sufficient concern that defendant will suffer actual prejudice if Ms. Bradley is allowed to continue serving as a prosecutor in this case. The prosecutor in this case has demonstrated that she, not just her witness, is willing to lie and prejudice prejudice defendants in this case. So the court just flat out says there, There is sufficient concern that defendant will suffer actual prejudice if Ms. Bradley is allowed to continue serving as a prosecutor in this case. Even though it is far from conclusive, the court is sufficiently concerned about whether Ms. Bradley has departed from her role as a zealous advocate for the state and is now personally invested in the credibility determinations of Detective Moretti and Ms. Boutros and the outcome of the trial. If she's no longer, it looks like there's a possibility she's no longer acting on behalf of the state and she's just acting on behalf of her own personal interest to inject herself in this, which she's done. So although a court does not conclusively find that Ms. Bradley's integrity and veracity, truthfulness, trustworthiness. So although the court does not conclusively find that Ms. Bradley's integrity and truthfulness as a prosecutor has been compromised, not conclusive. We haven't found conclusively she's a liar. The court is cognizant of the grave importance of protecting the defendant's constitutional rights, particularly in a first-degree murder case in which he is facing the death penalty. In an abundance of caution, the court is sufficiently concerned that the defendant will suffer actual prejudice from the continuing representation of the state by Ms. Bradley, given the likelihood that she is now personally invested in the outcome of this case. Based on the above, it is ordered and adjudged that defendant's motion to recuse 17th Judicial Circuit Assistant State Attorney Christine Bradley is, bold, all caps, underlined, granted. Done and ordered in chambers, Fort Lauderdale, Broward County, Florida, on this 12th day of October, 2023. And there you have it, folks. Whew. That's Ms. Bradley getting the boot. So we asked why was she booted off the case? What did the judge find? That is what the judge found in issuing the order. Well, how do you like them apples, Bradley? So now she's off the case. There's a new prosecutor on the case. She's a bulldog with this. She's already filed 7 new charges against Melly in relating to witness tampering. She's making lots of motions herself. She's being very, very aggressive in this, but boom, there we go. Bradley, that's the reason Bradley was pulled off the case. Now she's a witness if Moretti takes the case. And as I said before, it seems to be that the prosecution, the state is trying to find a way to introduce the evidence necessary for a conviction without calling Moretti to the stand. There's been a couple of things that have sort of maybe trying to signal that if there's someone else that can testify as to the evidence that Moretti testified to last time, so they don't have to call Moretti as a witness, which means they don't have to, they won't be able to call Boutros and Bradley to the stand to impeach Moretti. I don't see how they can get a conviction without calling Moretti to the stand because he was the lead investigator. He signed off on a huge number of the affidavits relating to search warrants and whatnot in the case. It's going to be a problem if he's not testifying. Well, this still leaves open the big question. Why wasn't everybody in the prosecutor's office thrown off this case? Well, we'll save that order for next week. Next week, probably next Tuesday, as a matter of fact, we'll look at the order denying the recusal of the 3 other prosecutors that were mentioned in that order, the ones that were above Boutros and Bradley. We'll read that. We'll read that motion next week, so you can find out why the entire office wasn't thrown off the case. That's what we'll do next week. Let's see. We've got a couple of things to read here. And by a couple, I literally mean a couple. Unhung Hero, thank you so much for the super chat. You can't be a prosecutor and witness unless in Kenosha. Right, Gravely? Gravely should have been thrown. Gravely, whatever you want, Gravelhead should have been thrown off the case the minute it became clear he'd inserted himself in as a potential material witness in the Zachariah Anderson case. But Judge Old Softhead just said, "No, can you just step out of the room while she's testifying? That'll solve the problem." Which it really didn't. Yeah, so there you go. You can't be a prosecutor and a witness unless in Kenosha. And Valhalla awaits with his usual refrain. Where'd he go? There we go. Get wrecked, Gravely. And that dog in him. Thank you, that dog in him, for another super chat. Oh, it wasn't a super chat the first time. It was just a maximum snark request. That dog in him. Imagine you blowing your case wide open because you didn't want to prejudice your lead investigator. Well, she didn't want to. She didn't want to screw herself. So, in the process of trying not to screw herself over for violating Brady rules, she essentially made up 4 different stories as to what happened to try to cover her own ass. Didn't work. She got nailed. But we do have some other motions from the new prosecutor to get through, some new things as well. For example, we're going to be looking at the affidavit regarding witness tampering and the tampering information, the criminal complaint regarding the 7 charges of witness tampering. And we will be looking at the motion that the new prosecutor has filed to have the charges, to have the information regarding the jury tampering charges included in the murder trial to show evidence of the defendant's guilt. That's what they want to use. They filed 7 charges of witness tampering against Melly and Bortland. Now they want to use that in this trial to show, see, he had a guilty mind. That's evidence of his guilt. He had this guilty mind because he's trying to tamper with the witnesses because he has a guilty mind and he's trying to hide. That she filed a motion to do that. Well, that's another thing we'll talk about. Absinthe Minded said, can defense call Moretti and Bradley's hostile? Well, Moretti's going to get called by the prosecution. The defense has already said when Moretti gets called, they are putting Bradley on as a witness. So yes, Prosecutor Bradley will be testifying for the defense in this case, most likely. That dog in him says, would you intercept me? I'd intercept me. Why would I intercept you? Arian the Vegetarian says, Jeff, I'm as bad as Bradley for bearing false witness against my neighbor by telling my 4-year-old you're going to jail for saying bullshit, so he'd stop repeating it. No, I know that's not bearing false witness against your neighbor. You're not saying your neighbor did something. You're not bearing false witness against your child. You're just lying to your child. Don't ask me, ask God. That's just my interpretation. But I tend to take a very liberal view of forgiveness for sins and a very narrow view of what sins are. So it works out for me. No, I said the prosecution is trying to find a way not to bring Moretti because it looks bad, but I don't think they can. And if they don't, if they don't, there's really no reason for the defense to call Moretti. The trial's coming. It's just been delayed because the entire jury panel was thrown out. So trial is coming. It's just going to probably start sometime in February. So we'll get there. Now, to wrap this up, there was a law and crime sidebar. I almost called them the law and the other C word. There was a little sidebar thing with Jesse Weber that was broadcast about 15 hours ago. And I wanted to watch that because there's some comments by a former lawyer of YNW Melly. And he made a couple of interesting comments about Moretti in there that I thought were kind of interesting. So let's bring this on up as the last thing we do today. And how are we doing here real quick? 500 concurrent viewers. Hey, 500 peeps and 387 likes. So 100 more likes. Let's get down there. We can do 500 likes easily. We can do 500 likes in the next 6 seconds. In the next 2 seconds, if everyone just does it. Let's see if we can get up to 500 likes. That'd be super awesome. And we've done well today with the likes. Thank you so much. Please, if you haven't subscribed, take a risk, take a chance on me and subscribe to the channel. And let's watch this YNW Melly trial together. And if you have subscribed, just double check, make sure you still are. And with that, let's go look at the sidebar. There's a whole lot of background information we don't need to worry about. There we go. There's Law Guy there. All righty.
You also want to raise it because you want to protect your client's interests as best that you can. So any single issue that you can come up with as a defense attorney, you want to raise it on objection. And if the judge, buys your argument and then strikes a jury panel or does something else, he's taking away that possible appellate issue. So in this case,
that's what Steve was talking about.
The defense really wanted to strike the whole panel. I don't know if they really did, or if they did that as more of a strategic move where the judge might have denied it, and then that just raises another appellate issue if he didn't strike the panel. But I think in this case, the judge is doing everything possible to really take away any kind of possible appellate issue because he sees this case that might come back in the future.
That's what that's what Prophet Stephen Gosney was just saying a while ago at the beginning. So there you go, Steve. Using his mental powers to predict what the judge was doing, which also seems to be what everyone else is doing. Duncan, Idaho. Thank you so much for the 5 Legal Vices memberships. If you're one of the lucky 5 that gets a Legal Vices membership gifted by Duncan, Idaho, please give him a super special thanks. Thank you so much, Duncan, for your kindness and generosity. And Steve, if you're still here, take a bow. Take a bow for guessing it.
In case there's a conviction.
Hey there, everybody. I want to talk to you right now about Palm, which they misstated the law at the very beginning of the case. You know what? I would say, and then the law is reiterated to me the proper way. I could see the defense's argument, that the jury.
Oh, hush. That's not what I want to hear.
And that's the reason why it was you were moving to strike it. So certainly it's not unusual to strike a whole jury panel for different reasons. I mean, there is a local attorney who's absolutely great. He's a good friend of mine who struck a whole jury panel because all of
vodka blood vices get an ad blocker. One, you should never, ever, 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 ever use an ad blocker on YouTube because that's wrong and it's horrible. And not only does it take money away from YouTube, it takes money away from me. Never use ad blockers. Ever. Ever. And 2, if only ad blockers would stop talk show hosts from talking about products that their wife thinks is really cool, that would help.
Their last name started with the letter C. And they said it's impossible that this is just a random thing, that every single juror is she or he, their last name begins with C. It was a federal case, and the judge actually struck the whole panel. He thought it was unusual as well.
I'm not sure I understand that.
Jim, that's old video.
You don't even know their identities, the jurors.
I think that he was
basically where are we here? Stop talking about that.
Defense is going to raise objections on whatever they want to raise objections on. I think it's an interesting motion. I think it's more for the press than it is that the judge is actually going to say, hey, you guys are right. I'm not going to allow them to do this. That would never happen. I think it's more to show the press why it happened and kind of put some dirt.
All right, I think they're going to move on here in just a second.
I there was another part of this that I thought was really interesting, and I guess you could understand why the state is frustrated, because they have also said in this filing that 3 jurors have complained about improper conduct. Like, for example, there was a juror number 3 who said that people were approaching the jurors or were talking in their presence. And this juror number 3, actually said that when she was outside the courthouse, someone came up to her to discuss her jury service on, quote, the Rappers case. And despite all of that, the state didn't move to strike the jury panel. And that seems pretty serious, what's been happening with the jury.
Allegedly happening with the jury.
The jury panel was completely excused because of the defense was concerned that they might look bad. So if that is all true from what the state says, what do you make of it?
I think it's highly unusual in cases where it's a high profile case, and I've had a lot of high profile cases. Had a lot of high profile trials. When you have a high profile trial, people want to approach you, just normal people that are watching the case, that have interest in the case. I mean, the people that watch your show, that listen to your show. I mean, these people have a lot of interest in what's going on, and not only that, they have a lot of interest in the evidence. Sometimes they know the evidence better than some of the lawyers. Sometimes they know the law.
Oh heck, a lot of people out there know the evidence a lot better than the lawyers, because they're just that way.
All better than some of the lawyers. I mean, it's really the era of people getting involved in these cases, from when it was O.J. Simpson and everyone was kind of just watching on TV, to where it is now, where everyone is kind of their own detective or their own lawyer and kind of figuring things out, I think has grown so much and so substantially that it doesn't surprise me that random people are going up to jurors and trying to get them to talk to them. But it is, like
random people.
It's improper. It's not allowed. A juror is not allowed to discuss their service. And I know there was some issues where one juror was saying, "Oh, Melly's mom is looking at me weird."
Yes,
things like that.
That's what we talked about last week.
Are very minimal because family members are going to be upset when their family members on trial. So those things will happen, and people will be looking at you because you're a juror, and they want to see if you give any reaction, if you smile, if you don't smile. Those things everyone's going to be looking at. But if there's no physical contact, if there's no talking to each other, very difficult. Other than that, to say, okay.
Well, it did get the judge did say that that Melly's mother needs to stay away from the jurors, not be anywhere where they congregate or where they leave and enter the building. She's not to have any eye contact with them, et cetera, et cetera.
We need to strike the panel.
Dale Bowen asked, how long has he been incarcerated? About 5 years at this point, with no trial.
I do find it, like I said, troubling that
2018 October, I believe.
To talk to them. But, that happens a lot in high-profile cases.
And look, like you said, the prosecution, this is a second round for them. They want a conviction. They don't want another mistrial. So they're trying to, make sure everything is going accordingly. But look, it's tough. At the time of this recording, we're still in the jury selection process. We'll see when they actually select a jury. And then we'll see, hopefully during the course of the trial, that we don't lose jurors because of these kinds of issues. Having said that, you mentioned something, and I have a bonus issue for you. You mentioned detective. So I wanted to also ask you your thoughts on this other issue. The judge in this case.
This is before we get into this last little part. Daily Quickbite says, so given that they can't call their absolutely vital witness, they can. There's no reason why they can't call Moretti. He's just going to face a very, very brutal disqualification or impeachment process during the state's trial. I mean, during the defense's case in chief, they're going to put people on to impeach him as a witness. So they can put him on. He's just going to undergo a brutal impeachment process during the defense case in chief. So, yeah. Don't they have a duty to dismiss since they can't prove their case beyond a reasonable doubt? Again, they can still put him on. The jury can still believe him, or they can find another way of putting in the evidence without calling him. If they can do that, I think they're going to not call him. But I don't see how they can prove it without calling him. So I think at the end of the day, they're going to have to call him, and his impeachment is going to be brutal.
Ordered that the lead detective, Mark Moretti, is going to have to be interviewed by Melly's defense team again.
That's on the
Usually in
17th.
Florida, you know that
2 days from
witnesses
now,
can
3
only be
days from now.
deposed once unless the judge decides otherwise or the parties agree. So here, the defense is going to ask Moretti about his.
Well, the
credibility,
defense is calling
not
them
any
both.
evidence about the actual case.
Yeah, Creed, the defense said they're calling them both. They're calling Boutros and Bradley to impeach Moretti if Moretti takes the stand. So yeah, they're going to call both. And that also answered. Oh, you already asked that. Okay. Again, you said why not call Prosecutor Boutros? Croatian don't know how to spell it instead of Bradley. I said they're calling them both. So yeah, it'll be fun. Can't wait for this trial to actually get underway. It'll be fun.
But it concerns whether Moretti solicited a sheriff's deputy to lie, namely telling him that he should say he was there when a search warrant was executed on Melly's mom's phone. The defense suggested this could actually be Brady material, meaning evidence that the state has to turn over that may help the defense's case. Remember, Melly's team already accused the former prosecutor, who's no longer on the case, Christine Bradley, of a Brady violation. So this idea, first, that he's going to have to sit and talk about, did he kind of persuade a sheriff's deputy to lie and say he was there during the execution of this search warrant? That's a big allegation. I'm curious what you think.
Yeah, it is, Mr. Hare.
You know, I always like to say that police officers always tell the truth, but I've had instances where they don't. I mean,
really,
you know,
he's had incidences where the police and the prosecutors haven't told the truth.
For better or for worse, police officers, doctors, lawyers, everybody is a person, right? So everybody does things that are right, does things that are wrong, gets nervous just like everybody else gets nervous. So I've had dealings with Detective Moretti before in the past, not good ones.
I've had dealings in the past with Moretti, not good ones. That's an interesting statement. And again, this guy was Melly's lawyer early on in the game, earlier on in the matter. He's also represented other rappers and things, but he's also had bad encounters with Moretti. Surprise?
And it doesn't surprise me when I heard what was going on. And I do think that they're entitled to take his deposition again, because I think that all the quagmire of who's telling the truth, who's not telling the truth. And don't forget, for your audience, a Brady is exculpatory evidence that may tend to say, hey, this guy didn't do it, or it may be something to someone's credibility for telling the truth. That also is Brady evidence. That's why they're saying this is Brady evidence. Now, in the past, 3 Brady notices on Detective Moretti were filed. One saying one thing, then one correcting what the first one said, and then the last one saying, no, the first one was right. So
well, didn't you say the first one was right? It said,
I just think that I'm going to be watching and listening very closely, because I think that this is the tip of the iceberg for Detective Moretti in terms of what he's going to say at this deposition, because I think there's going to be some complaints filed. I think that there's going to be a bigger issue that comes about. And if you recall, and this was some inside baseball, and I talked about it on your show once before, at the very beginning of this case, when I represented Melly, and I also represented Portland, everyone knew I was representing them. Everyone knew they had attorneys, and everyone knew that they were invoking their Fifth Amendment.
Now listen to this shit. This is another example of what Moretti did. Moretti knew that Portland and YNW Melly were represented by this guy. Knew they were. And here's what he did.
Amendment. Knowing all that, Portland got arrested in Texas, and he was waiting to be extradited to Florida. And detectives, including Moretti, flew over to Texas to try to get him to give a statement, even knowing that he was represented by counsel. So, when someone does something like that, it doesn't surprise me when I hear other allegations. So I'd like to see what's going to happen. Listen, this is all fair game. When he's on the stand, the state may not want to even call him. And then he'll be a defense witness. They'll call him to the stand. They'll ask him what he did, and then they'll attack his credibility.
Yeah, and don't know if it'll be through, a deposition, an interview. We don't know exactly what he said, what the deputy said. You mentioned the prosecution.
He's just screwed no matter what they do.
It shouldn't even be admissible at trial. It can't be used to impeach his credibility, because they say Emmons didn't reach out to his mom. He didn't ask her to do anything. So this whole issue about the execution of the search warrant on the phone doesn't even matter. And I'll give you a quick response to that. What do you think?
Yeah, I think it does. I mean, anything that a detective does in a case that is going to be relevant in terms of his credibility is always going to be relevant in a case. So if he's serving a warrant on Bob Smith and Bob Smith doesn't have anything to do with my case, or he's tangentially has something to do with my case, and he lies about something in that service of the warrant, I think would be relevant to his credibility because he served warrants in my case and he's served warrants on my family and he's done investigation and looked for things and said he found things. All these different things would go. I mean, like I said, I don't like to keep bringing up O.J. Simpson's case.
No, yeah.
But Furman.
The fact is that in O.J. Simpson's case, you had Mark Furman who, says, I never used this certain word. Well, how would that even be relevant? If you think about it, like, how would that be relevant in the case? It's relevant because he made it relevant. I've never used that.
See, and that's a good statement. We'll get rid of this stupid advertisement. That's a good statement right there. It's not in and of itself saying I've never used the N-word. If anyone says I use the N-word, they're by default a liar. I would never use that word. I would never drop the N-word. That's not relevant to whether O.J. Simpson killed somebody or not. Well, it wasn't relevant until he made it relevant and said, I have never done this. So therefore, if he's proven to be a liar about one thing, you can assume that he's lying about everything, and you can throw his testimony out, which means throwing out the bloody glove, throwing out the blood drops on the Bronco, and a bunch of other stuff that coincidentally only Furman found. And this is the same thing here. Did Moretti asking this guy to, so does that affect whether or not Melly murdered people? No, not in and of itself. But when you say or do something to make your credibility relevant, then it becomes relevant by what you did. And that's essentially what we have here.
That word before, and then all of a sudden, holy cow, well, here, let me play a tape for you, and F. Lee Bailey, the rest is all history, right? So that I think that things that affect your credibility are always relevant in a trial, and no one can sway me from that opinion.
I agree with you. I mean, how many times, and any of our followers will know, when we have like experts on the stand, under cross-examination, their past review, their past reports in other cases are brought in to suggest, are they biased? I remember one expert who always seemed to find in every death penalty case that there was some sort of mental defect in the defendant, in the killer. Like everyone, and always said that, and they looked at his past cases and said, have you ever found one where you didn't find it? And so it looked like it was a hired gun. And so it's an interesting kind of debate, an interesting argument. Bradford Cohen, thank you so much, sir, for coming.
All right. Well, that's kind of the important thing. I just wanted you to hear that this lawyer's also had other dealings with Moretti, where Moretti knew he had a client who was exercising his Fifth Amendment right. So the client is in another state, so Moretti flies to the other state and tries to get him to talk without his lawyer present. Shady dude. He's got some answering to do. Regardless, I mean, it's ugly. I think. I mean, of course, I could never guess how this retrial is going to turn out, but the prosecution, Bradley, by not turning over that information regarding Moretti before the first trial, unleashing this entire can of worms, getting herself booted off, having the credibility of Moretti just brought front and center. I think the state's ability to get a conviction during the retrial has been made exponentially more difficult. It's going to be ugly when this thing gets to a retrial. And that's where we stand. So you keep that in mind as we go forward. What's happening with this? And as I said, next week, we're going to be looking at probably the new charges against Melly. No, I lied. I went all Bradley. I misinformed you. Next week, we're going to be looking at why the rest of the prosecutor's office weren't explicitly booted off of this case. We'll look at that order, at the court's order for that next time. In the meantime, we'll keep you updated on any other news that comes in. And before we wrap this up, let's check out what's going on here. Looks like we are all caught up on the super chats and the monthly notices. And if you want to get any in, now is your chance to do it. We got Strawberry doing the chicken legs over here, looking like a little bit of fried chicken, or alternatively a loaf of bread. Right, I think that's it. We've got everything done that we need to get done today. Next week, we'll be looking at why the entire prosecutor's office wasn't booted. We will also be looking Thursday. Wait, tomorrow's Wednesday. Ugh. We're not even to Wednesday this week. It's been a long week. All right, tomorrow, Wednesday, we will be looking at the Alex Murdaugh case. The Alex Murdaugh case will be coming in tomorrow. And what are we going to be looking at in the Murdaugh trial, you ask, for tomorrow? You don't want to miss that either, because the defense has filed a motion, or they filed an application to the Supreme Court to have the judge removed from the case. Alex Murdaugh's lawyers want the judge booted off the case, and they've asked the Supreme Court to do that. We'll look at that motion. We'll look at the reasons. We'll look at that application. We'll look at those reasons tomorrow. Thursday, Chandler Remington will be joining me, as she does every Thursday, to co-host O.J. Simpson Throwback Trial. It's our chill stream Thursday, where we just sit and chill. We sort of do MST3K old trials. And we're coming to the end of O.J. Simpson. We've got about 2 more weeks of Andrea Mazzola on the stand. Just this probably tomorrow and the next week. Then we'll do closing arguments. Then we'll do the verdict. Then we're going to start on a new old trial. A new old trial where Barry Scheck, who destroyed Dennis Fung on the stand for about 8.5 days, was the lead defense counsel. We're going to be looking at one of his cases. So that'll be an interesting thing. That's a relatively short trial. So we'll cover the whole thing from opening to the end of the case. And Friday is going to be F-it Friday, so stick around for Friday. We'll be starting at an interesting time, about 10 a.m. Eastern time on Friday, and that makes it 3 p.m. UK time, and just ass early for people in Eastern Australia, sorry. So that's when the F-it Friday will start. We'll have a kind of a reduced panel. We had a bajillion people last time. We kind of got to break the groups up so there's not 100,000 million people, because we all know how well it goes when you get lots of people on the panel shouting over each other. We need to have smaller panels. We'll work on something. We'll keep it going as long as we can. Make sure you bring all of your shekels, dollars, dineros, sexy Swedish monies, and all your IUDs from the Middle East and whatnot. Bring them all here. Throw them all at my feet. We're going to have a boozy, drunken griftathon on Friday for F-it Friday, the Thanksgiving edition. Then next Monday, more Maritime Monday. Tuesday, YNW Melly. That'll take us through the next week. Thank you, everybody. That's all I've got for you. Any last words? No. Oh, there you go. Okay, thank you. Just only lick the leg there. And on that note, we'll say goodnight to the doggo Strawberry and Yoda. Good night, dogs. Good night, mods. Thank you so much for being here. You mods are the moddiest mods that ever modded. Love you guys. Couldn't do this without you. Thank you for keeping the bots at bay. And chat. As always, the greatest chat on the entire internet, the Vice Squad, of which you are all a part. Hats off to you guys for being here, for showing up, for having a lively chat, and for supporting me with the channel. Thank you again so much for the super chats, the monthly memberships, the memberships donated. Thank you for everything. We'll see you all tomorrow for Alex Murdaugh. Now, it's that time to say goodbye, folks, and let's see where we land today, shall we? Let's spin the wheel and see what happens. Good night, everybody. We'll see you tomorrow.